हमारा तो आई एम 24 आवर्स अवेलेबल, जब वो बोलेंगे हमको बोलेंगे, ठीक है, कोई कंसेंट का जरूरत नहीं। नेक्स्ट वीक में थोड़ा सा दिक्कत है, एक आध दिन, तो वो हमसे बात कर लेंगे।
That I will communicate.
The Chief Justice always said in this situation, the star judicial has to be approached for
Yes,
assignment.
अब वो आते हैं हम लोग के पास, पूछते हैं आप क्या
सब्जेक्ट नहीं, असाइनमेंट हैज ऑलरेडी बीन डन।
असाइनमेंट की बात नहीं है, कॉन्स्टिट्यूशन और बेंच के लिए भी वहाँ आप जाइए, हमारे पास फाइल आता है, हम लोग अपना डेट्स देते हैं, है ना, दैट इज द प्रोसीजर। आप उस अपने प्रोसीजर को फॉलो करिए, रजिस्ट्रार जुडिशियल के पास आप जाइए, ही विल गिव यू अ डेट।
Normal procedure है, normal procedure. When the bench matter has been assigned to another bench, then the senior judge belongs to normally ask the counsel that get consent from.
सर ऐसा प्रोसीजर हम तो नहीं देखे हैं।
नहीं सर, ऐसा है।
और ऐसा एक आध बार ऐसा हुआ है सर
ऐसा
कि एक आध बार ऐसा हुआ है, मेंशन करते हैं ये आज ही जुडिशियल के पास, उसके बाद वो हम लोग के पास फाइल लेके आते हैं, फाइल में हम लोग अपना डेट देते हैं, हम लोग आपस में बात करके डेट डिसाइड करते हैं। अगर मान लीजिए आज हम बोल दें कि हम मंडे को अवेलेबल हैं, पता चले कि हमारे सीनियर जज मंडे को अवेलेबल नहीं है, तब क्या होगा? इसीलिए ये हमारे एडमिनिस्ट्रेटिव साइड में होता है सर, ऐसा।
कंसीडरिंग द अर्जेंसी, कई बार ऐसा होता
सर
है।
आप हमको बताइए, अगर मान लीजिए आज हम अभी इनको बोल दें आई एम अवेलेबल ऑन मंडे एंड माय सीनियर जज इज नॉट अवेलेबल ऑन मंडे, तो कैसे होगा?
नहीं तो उसके बाद वो लोग फिर
तो आपस में हम लोग की बात जरूरी है ना, यहाँ से हम क्या ही कंसेंट देंगे। और देखिए लास्ट वर्किंग वीक है, हो सकता है कभी कोई रहे ना रहे, भाई वैसे तो हम नॉर्मली रहते ही हैं, लेकिन
नॉर्मली कहते थे कि पूछ लीजिए उनसे बात का।
देयर इज अ लाइक्लीहुड कि नेक्स्ट वीक में एक आध दिन हम ना भी रहें, तो इट्स इज, आप पता है अभी ब्याह शादी का टाइम है, बहुत तरह का बात है।
अच्छा,
एडमिनिस्ट्रेटिव साइड में हम लोग अपने कंसेंट करके डेट देते हैं, आप आज ही सबके पास जाइए, वो फाइल प्लेस करेंगे।
डेली काउंट सीरियल नंबर 12 WPC 2434/2018। May I permitted to withdraw on the instruction of Mr. Nagin?
सीरियल नंबर 12।
Yes, sir. WPC number 243।
WPC नंबर 2434 ऑफ 2018। नाम बताइए अपना।
गोविंद राय करन।
मिस्टर गोविंद राय करन, आपका भी तो वकालतनामा है। ऑन इंस्ट्रक्शंस undertakes to submits that he wants to withdraw this with petition। कोई इंट्रीम ऑर्डर वगैरह तो नहीं है? Accordingly this petition is dismissed as withdrawn। साइन कर दिया और लिख दीजिए ऑन इंस्ट्रक्शंस ऑफ हिज सीनियर मिस्टर नागमणि तिवारी।
Item 2425 supposed to be at airport by 12:30, 12 o'clock, because एक शादी में मुझे पटना शाम में पहुंचना है, सिर्फ नॉट टुडे यदि कर दिया तो हम कंसेंट ले लिया 24-25 से।
कब करना? कंटेंट में आप चल रहे हैं ना, क्या चल रहा है एलपीए में?
हुजूर उसमें रिव्यू में हम लगी थी, हुजूर का डायरेक्शन था 25।
एलपीए में क्या चल रहा है?
एलपीए में रिव्यू है,
इसमें एलपीए में तो फाइल,
एलपीए उन लोग फाइल किया है।
हाँ
वो डिफेक्टिव छोड़ा हुआ है फाइल करके, उन लोग फाइल किया है, हम तो हुजूर के शरण में हैं। नॉट
टुडे कर दीजिए पासवर्ड।
अब लग
इनका नाम लिखिएगा, काउंसिल फॉर द पिटिशनर्स सीक्स एडजर्नमेंट ऑन
Respondent
पर्सनल ग्राउंड्स।
हम रिस्पोंडेंट
रिव्यू में तो पिटिशनर है,
हाँ रिव्यू पिटिशन, रिव्यू पिटिशन
भूलते नहीं हैं हम इतना आसानी से कोई चीज़,
हम ही गड़बड़ा जाते हैं।
ठीक है।
रिव्यू में हम पिटिशनर हैं।
ओपनिंग फ्राइडे डाल दीजिए 3 तारीख।
अब लग
From submission is for final disposal item 1 WPL 5095 of 2012।
In this case on behalf of Ms. Prerna Zunwala, she fell to rest.
We have heard her now. To be here, we have heard her. We have heard her fully yesterday.
While coming to the court, she fell
Sorry?
while coming to the court, she fell from the stairs. That's why I was praying for not today.
She is an amicus in this case. I think we have heard her yesterday. चलिए कब करना है बताइए?
Monday or Tuesday, any day.
WPL number 5095 of 2012. Mr. नाम बताइए अपना.
सागर कुमार.
Mr.
सागर कुमार.
Sagar Kumar. Submits that on account of personal difficulty, the learned amicus appearing for the petitioner is not in a position to attend the court. He submits that the matter be posted on Monday. Post on Monday. To be taken up at 2:15. नहीं 10:30 बजे पहला केस. First case at 10:30. है already. अच्छा 2:15 first case.
I will send some judgments.
कुछ नहीं है. Judgment भेज दीजिए आप. कुछ नहीं है. You see, we have read it fully.
My lord,
हर चीज consider करें.
Yes.
In fact, that the letter which was sent, that withdrawal of resignation was sent to the MD, not to the concerned person. तो आप भेज दीजिए कहीं पर भी, प्रेसिडेंट को भेज दीजिए, सेक्रेटरी को भेज दीजिए, इससे क्या ही होता है?
It doesn't work like that.
It doesn't work like that. It ought to have been sent to the concerned person who was to accept the resignation.
Well,
ऐसे आप भेज दीजिए.
Lord.
For orders with effect, item 2, civil review filing number 11297 of 2024.
Yes, defect.
Yes, no, defect, that is only one defect, madam, so far as
You remove it.
तो नाम का है जो, वही तो हम कह रहे हैं कि मेरा जो असली नाम है हम वो लिखे हैं और वो रीट में मेरा नाम दूसरा
आपको
लिखा है.
आईए फाइल करना पड़ेगा ना उसके.
आइए फाइल किया हुआ है.
अच्छा, तो फॉर व्हाट?
हाँ, फॉर रिमूविंग दैट डिफेक्ट. उनको लास्ट टाइम कहा गया था जो काउंटर एफिडेविट.
आईए नंबर कौन सा है आपका? 42.
आइए नंबर 12186.
क्या बोलते हैं आप इसे?
इसमें हम मेरा वही कहना है जो मेरा जो नाम है
आपको इसमें काउंटर फाइल करने के लिए बोला गया
हाँ,
था?
इसमें काउंटर कहा गया था ये आइए का भी फाइल करने लेकिन
अभी फाइल या काउंटर?
काउंटर है नॉट टू दिस आइए मैम. आइए का भी
तो
कहा
दिस आईए.
आइए का बस काउंटर वकालतनामा काउंटर फाइल में
लास्ट ऑर्डर अपलोड नहीं हुआ, नहीं देखे हैं. नहीं देखे लास्ट ऑर्डर.
मिस्टेक होगा माय पार्ट मिलो बिकॉज़ काउंटर इज देयर मिलो राइट.
अरे आईए में नाम का डिस्प्यूट है, आपको पता है ना?
अब तो देखा चाहिए
झारखंड में सोमरा, मंगरा, बुधवा, यही नाम, 7 ही नाम है पूरे झारखंड में.
एलियस के में
आपको मालूम है ना 7 ही नाम है झारखंड में. Only 7 names are there. So you have to file a response to this idea. नाम में dispute is something very serious. अब फाइल करिए. Civil review number या filing number दीजिए. You are for the private respondent.
इसको नंबर
The learned counsel for the private respondent prays for time to comply the order dated 29th of November 2024. Where is the state council? State is also equally important. Whenever there is a dispute regarding name, they need to file a counter affidavit.
I will convey it.
Kindly convey. The order is also required to be complied by the state council. ये this word calendar दीजिए. The needful be done by the respondents by 10th of January. उसके बाद वाला Friday का दिन दीजिए. थोड़ा सा एक स्मॉल वेरिफिकेशन करके करा दीजिए. टेंथ के बाद वाला कौन सा Friday? 17. नाम को लेके बहुत झारखंड में इश्यूज है नाम को लेके.
इसलिए हजूर हम काटे नहीं उसका नाम, जो ओरिजिनल नाम है हम लिख दिए कहा कि भाई हम अपना नाम बदलने के पिटिशनर के चलते सबसे दिक्कत है.
For orders item 3, WPC 5138 of 2008.
Yes, petition.
My lord, because this case was taken, the file is untraceable in that office. They said they will get a copy from the respondents. And
So you will do it.
that is what I managed to gather. I've been following up with my old office. Your Lordship will see that in 2023, coordinated by, I issued notice to the petitioner also because no one had appeared. I don't know the result of that notice. I can place that order. 9/11/23.
Unserved notice has not been issued. Service report has not been received. How do we trace? We just do not notice for you to trace it.
Your Lordship may keep it next week because from the party position, I see that the state is not the party.
For taking steps for engaging the council for appearing in this case.
Yes.
I think this organization is liquidated. Should we dismiss it on account of no instructions?
Let it be next week, any day, Your Lordship, by next Friday perhaps. I will appear and assist Your Lordship on this.
Respondent is also not appearing.
Respondent, the names are there. I will try to get the file from one of them. The RP, Regional Provident Fund Commissioner Ranchi. 4-5 names are appearing, but nobody seems to be there.
You call Mr. Patti. Next time, next day.
Yes, Your Lordship.
WPC number 5138 of 2008. Mr. Manish Mishra, advocate, submits that. He does not have any up-to-date instructions in the matter. The petitioner has not contacted him since long. The matter is pending since 2008. He has also submitted that notice was also issued to the petitioner, but the service report is, as per the office note, the SR or unserved notice has not been received. He submits that it appears he submits that the matter be posted next Tuesday.
Right.
Post on next Tuesday at 15.
Item 4, Contempt Civil 674 of 2024.
There is no stay. I think the amount must have been realized by now. Must have been.
If you can find out.
Yes. Yes. Affidavit.
We have filed on 10th. So far as the order of read is concerned, with regard to gratuity and leave encashment, that has been complied by passing the reason order. Thereafter, the petitioner has filed the rejoinder, and we were directed to file reply to the rejoinder.
To the tabular chart.
To the tabular chart. But from bare reading of the order passed by the in the read petition, the only issue is remaining gratuity and leave encashment. Upon gratuity and leave encashment, reasoned order has been passed.
Was there any direction? Was the order limited to gratuity and leave encashment only?
Yes, madam. Petitioner had prayed for ACP and MSP. That was declined, by filing IA, they have prayed for payment of ACP and MSP, that was declined.
Let us see the nature of order.
Yes, madam. Kindly come to page number 51, that is the order. relevant is from page 33, para 11.
Let us see the prayer.
Yes, page 31. This writ petition has been filed for following reliefs for issuance of appropriate writ in the nature of mandamus for any other appropriate writ or the direction commanding upon the respondent to fix and release at once the pension in old pension scheme of the petitioner along with the following retirement financial scheme, pension commutation and pension cum retire benefit, gratuity, leave encashment, TA for settlement at a station after retirement benefit which is due from 31st March 2023. Henceforth, disbursement of entire gratuity amount, immediate fixation cum commutation of current final pension which is due from the date of retirement which is 31st March 2023. Forthwith, disbursement of entire amount of areas of pension for the period commending from 31st March 2023. Forthwith, release entire payment of amount of unused earned leave, any other release earned leave. Kindly, my lord, have a look to para 11 of the page 33.
Yes.
This court is of the considered view that if the IA number 10856 of 23 is allowed, the same will change the nature of writ petition. Accordingly, this court is not inclined to allow the interlocutory application. However, the right is reserved to the petitioner to take appropriate steps with regard to relief which has been paid for the interlocutory application so and so. With regard to quantum of pension and other consequential relief, if the petitioner has any surviving grievance with respect to quantum of pension. So, my lord, they have filed the IA for ACP and MSCP that was declined by in para 11 number. Now, my lord, so far as the payment of leave is concerned, it has been stated in counter affidavit of the state that the matter is under active consideration for respondent number 4. In such circumstances, the respondent number 4 is required to expedite the matter and take a final decision within a period of 4 weeks from the date of receipt of the copy of this order. The petitioner shall file a detailed representation before the respondent number 4 with supporting documents. In the case petitioner requires personal hearing, specific prayer be made in the representation itself for such hearing. The order in connection with the payment of leave encashment, unutilized leave should be reasoned order. The reasoned order is also required to be communicated to the petitioner through speed post. So here leave encashment, next para is with regard to payment of gratuity. So the order is only confined to payment of gratuity and leave encashment. And for that, direction was given to pass a reasoned order. The respondents have passed the reasoned order.
Where is that?
That is at page number 22 of the show cause. First show cause, filed on 2/9/2024. Page 22, Tarki Kadesh.
So you have denied the relief or what you have done?
Well, it is stated that as per the notification of 2018, Jharkhand Pension Sanshodhan Niyamavali, if the departmental proceeding or any criminal proceeding is pending against the employer, so that will be gratuity will be paid after the conclusion of that departmental proceeding. The list of the proceedings have been given in the next page. 8 departmental proceedings and 2 criminal proceedings are pending against the petitioner. So after conclusion of all those proceedings, that will be paid as per the Niyamavali of 2018. We have passed the reasoned order. Direction was only to pass reasoned order. We have passed the reasoned order. Page 34, my lord.
Just a moment. Basically, they were seeking mandamus, and
Yes.
now you have passed a reasoned order denying gratuity. What about leave encashment?
Leave encashment, my lord, the order was also there, my lord, at annexure B of the same show cause. Page number 25 and 26. Page number 26 is relevant. Clause 3, Roman clause 3. वित्त दावा निर्धारण कोषांग विभाग झारखंड सरकार का पत्रांक दिनांक 30/3/2024 के प्रासंगिक पत्र के आलोक में दिनांक 14/1/2012 से 12/8/2018 तक झारखंड सेवा संहिता के नियम 227 230, 248 के अंतर्गत कुल 208 दिनों तक का उपार्जित अवकाश तथा 120 दिनों का अर्धदैनिक अवकाश देकर संबंधित पत्र निर्गत किया गया है। वादी के विरुद्ध दर्ज आपराधिक कांड एवं संचालित विभागीय कार्रवाई के फलाफल के आधार पर वन विभाग द्वारा वादी के निलंबन कारावास अवधि पर निर्णय लिया जाएगा तथा तदनुसार पर वित्त विभाग द्वारा वादी के सेवानिवृत्ति तिथि का अवकाश अदेयता उपलब्ध कराया जाएगा। तत्पश्चात वादी के लिविंग कैशमेंट का भुगतान
So
संभव होगा।
whatever it is, you have disposed of both the claims.
Yes, ma'am. By passing a reasoned order, my lord, and direction was only to pass a reasoned order that has been passed and communicated to the petitioner.
What do you have to say?
My lordship, in the reply of their contents that departmental proceeding is continuing and several departmental proceedings is continuing, but I do not know what are the charges. From 2012,
Just a
the
moment.
departmental proceeding is continuing.
Just a minute. Between contempt case civil number 674 of 2024 for the learned petitioner in person and the learned counsel appearing on behalf of the opposite party. The learned counsel for the opposite party has submitted that the order passed by this court has been duly complied, and as per the order, only 2 grievances of the petitioner were to be taken into consideration, and a reasoned order to that effect has been passed. One was relating to leave encashment, and other was relating to gratuity. The premise that the reasoned order in connection with the same has been annexed along with the show cause, and if the petitioner is aggrieved by same, he may take appropriate steps, but so far as the contempt is concerned, no contempt is made out. The order has been complied, though belatedly,
That has been complied, my lord.
within time or belatedly.
No, my lord. Order is of 9/4/2024 and we have filed so called on 2/9/2024 after 5 months.
The learned counsel for the petitioner in person has submitted that he is not aware. No, he has submitted that the departmental proceeding is pending since 2012, and the same cannot be a ground to deny the benefits. Regarding payment of gratuity and leave encashment.
My lords, the leave they have utilized, and
The learned, considering the nature of order passed by this court finds that there was a direction to consider the grievance of the petitioner in connection with leave encashment and gratuity, and the reasoned order having been passed, the dispute raised by the petitioner in person cannot be decided in these proceedings. However, the liberty is reserved with the petitioner to take steps in connection with the reasoned order in accordance with it.
I have
The proceedings are next.
Co-admission. Item 5, Contempt Civil 1121 of 2023.
Order has been complied. Contempt civil 1121 of 2023. Counsel for the petitioner submits that order dated 13/6/2023 passed in WPS number 2903 of 2022 has been complied. Considering the submissions, this court is not inclined to proceed any further. This contempt proceedings are accordingly closed.
Item 6, Contempt Civil 768 of 2024.
Last occasion, also we had in the state to inquire about the stage of the appeal. But it is still pending now, it is in the advanced stage of completion.
Page number 60 is the order under offense number, which had not been complied. Relevant portion, para 39 on page number 60. of the contempt application.
It is on the verge of completion.
4 weeks trial they have requested.
Item 39, in the aforesaid circumstances, this court is of considered view that those petitioners teaching in class 1 to 5 to selection have been approved by competent authority under service rule of 2021 in terms of decision taken in 64th committee meeting of JEPC and whose educational qualification have been verified by the competent authority under rules of 2021. They are to be taken in service forthwith, subject to any interim order or final order by the
Why have you
appellate.
not taken the service forthwith? They were supposed to be taken in service forthwith, na?
That have to be
Subject to-
What ascertained?
JEPC is not that is the practice.
JEPC तो कुछ नहीं बोलेंगे, उनको तो करना ही नहीं है. कौन है आपके ऑफिसर? उनको बुलाइए ही. There was a direction to take them back forthwith. आप अपना करते रहते हैं, आपको जो करना है.
JPC preferred appeal matter for before the DC matter.
So, what is the order? DC से stay order मिला है आपको?
Yes, my lord. One stay order is there, but they are not deciding finally the claim.
So, once there is a stay order, because I remember that I have observed that if there is any stay order, then that will operate. Because we did not enter into the merits.
My lord.
Once there is a stay order, then they are not in contempt. कितना time लगेगा आपको decide करने?
4 weeks.
Contempt Civil 768 of 2024. The learned counsel for the parties are present. The counsel for the state has submitted that the appeal is at the final stage and it will take around 4 weeks time to decide the appeal itself. It has also been reported that pending appeal there is a stay order passed by the appellate authority. Since an order of stay has been passed by the appellate authority, this court is not inclined to proceed any further with this contempt case, which is hereby dropped.
My lord, what I was saying that they are taking 4 weeks time because that is also part of the order that they will decide it expeditiously. So after 4 weeks, my lord, because another round of contempt, my lord, that will. This order was passed. This honorable.
अच्छा कोई बात नहीं, सो रख दे, ठीक है? 4 हफ्ता बाद रख दे.
My
छोड़िए इसको लास्ट वाला क्वेश्चन में. Counsel for the state has submitted that the appeal is likely to be appeal will be decided within a period of 4 weeks
Will on instructions notes.
on instructions. किसका instructions?
DSC have asked.
हाँ, DSC को decide करना है.
But we have submitted at 4 weeks time. They requested. Case will be taken up after 4 weeks. In the meantime, the appeal may
You are
be
already in contempt, isn't it?
decided. Not after 4 weeks.
He submits that the state, the learned counsel for the state submits that the matter be posted after 4 weeks, and in the meantime, he shall file compliance report. Compliance report. Post this case on 24th of January 25. The compliance report will be filed by 22nd of January. Compliance report मतलब जो भी आप appeal decide करेंगे. There are 2 parts. One was they were supposed to be taken forthwith. Now there is a stay order passed. No problem. There is further order that you have to decide the appeal in 4 weeks time. There whatever was the time. So that part has already that period has already expired. So you annex the copy of the appellate order along with it. ठीक है?
When it is posted.
24.
Yes.
24 जनवरी. 4 हफ्ता मांगे हो गया ना 4 हफ्ता.
First of all, समय दे.
और समय नहीं.
Vacation
जितना
है.
मांगे थे उतना ही.
Vacation.
आपके ऑफिसर वेकेशन में है. नहीं है ना?
फर्स्ट वीक फरवरी में कर दिया, फर्स्ट वीक ऑफ फरवरी।
4 हफ्ता मांगे, 4 हफ्ता हम आपको देंगे बस बहुत।
From daily list of final disposal item 1, WPR 3402 of 2013.
Great. The application is on behalf of the union of the workmen. They have challenged their award, which has been answered against them. Okay. What has happened in this matter? That their employer is Blue Star company, has having the several branches all over the country, including at Jharkhand. They were working under the Blue Star company. On a particular date, when they went to attend their duty, they found that the door is closed and the notice is there that the factory is closed. This happened on 8th of September 1997. Then on the next day, they submitted their charter of demand to the management. And on the basis of the charter of demand, the conciliation started. On the failure of the conciliation officer reported the matter to the state government.
Charter of demand was filed before the management.
Yes, it was charter of demand just a minute. Charter of demand is part of the writ application, that is annexure A. Annexure A is order of reference.
Charter of demand was filed before whom?
Vice President.
On 9/9/97.
On 9/9/97, page 34.
Then when was the matter sent for conciliation?
Conciliation, that fact, we are not in a position that the state government should have, but the failure, normally this is the procedure. On failure of the conciliation officer reported the matter to the state government, and then the state government made a reference under section 10(1)(c). The order of the reference is annexure 1. Your Lordship may kindly, what are the term of the reference?
It is recorded in the award itself.
No, notification we have been closed. जो नोटिफिकेशन
अवार्ड में लिखा हुआ है सर?
नहीं, हम नोटिफिकेशन दिखलाना चाह रहे हैं। उसमें एक चीज़ और है, नोटिफिकेशन है एनेक्चर 1। एनेक्चर 1 में उसमें पेज 33 में आई, पेज 33 ऑफ द page 33, have you not got that? Page 33 means there is paragraph 3. In the middle, that will be in the middle, औद्योगिक विवाद, have you not got that? औद्योगिक विवाद बिहार नियमावली 1961 के अंतर्गत नियम 14 के अनुसार मोहम्मद बाउद्दीन के पत्रांक 0 दिनांक 9/9/97 की प्रतिलिपि संलग्न है, अनुलग्न। So this, the letter of demand is part of the notification. This I want to say. Then
But the terms of reference is whether the retrenchment
एक बार डिमांड
and announcement of closure.
एक बार डिमांड में एक पैराग्राफ को दिखला देते हैं, तब जाते हैं टर्म्स ऑफ रेफरेंस पर, पेज 34 में। ये दो तीन कुछ लाइन केवल पेज 34 में। We are shocked to see the door of Blue Star locked when we come to work on 8th of September 1997, we are further not to see your notice and letters addressed to employees along with the check draft purported to be that the final due. We are advised the employees, we are advising the employee to receive the check draft under protest for their survival and survival of their dependents. एक ही यही paragraph और दिखलाएंगे. To say the least, the action of the management in violation of the existing settlement between, besides being the violative of the legal requirements, the company has not followed any of the legal provisions before taking the above actions and before keeping the employee out of job. इतना ही तक दिखलाना था. तो वैसे तो और सब है, but so this were that, and then your lordship can come back to the term of reference. The term of reference is whether to retrenchment of the workman in Annexure K, named in Annexure K, and announcement of closure of Blue Star Limited Jamshedpur on 8/9/1977 in spite of business is justified. If not, what relief concerned workmen are entitled to. So two words have been used. Two words have been used. The first is retrenchment and the second is closure. So your lordship kindly take me the ID act दिया जाए. Retrenchment has been defined under section 200 and closure has been defined under section 2cc. So the first section 2cc you are kindly see. Closure means, I will not got that. The closure means the permanent closing down of a place of employment or part thereof. So this is the closure. And then 200 retrenchment, that says retrenchment means termination of employer of the service of a workman for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action, but does not include voluntary retirement of the workman or retirement of the workman on reaching the age of superannuation if the contract of employment between the employer and workman concerned contains a stipulation in that behalf, or termination of service of the workman as a result of non-renewal of contract of employment between the employer and the workman concerned on its expiry, or such contract being terminated under a stipulation in that behalf contained therein. And then lastly, termination of service of the workman on the ground of continued ill health. So this is not a matter of in exception. So only the retrenchment now the closure and retrenchment are dealt in the Industrial Disputes Act under two different provisions. So first, if your lordship kindly come, so far the closure is concerned, the industrial dispute rules जरा दीजिएगा सर. Industrial dispute rules, state rules.
State rules इसमें नहीं है. आप किताब लिख के दे दीजिए सर, मंगाना पड़ेगा ना, यहाँ तो रेडीली अवेलेबल।
स्टैट्यूटरी था तो हम समझे थे कि होना चाहिए था। Anyway,
तो बिना मंगाए तो क्या है किताब
एक्टर रूल्स तो एक्सपेक्टेड है कि कोर्ट में रहना चाहिए।
आपका एक्सपेक्टेशन कुछ ज़्यादा है हम लोगों से।
नहीं सर, ऐसा नहीं। हम अपना पास ऑन करते हैं थोड़ी देर के लिए, हम प्रोविजन खाली दिखलाना चाहते हैं। इसमें ये
बिहार रूल्स
हम बिहार उठा लेंगे। 76A रूल 76A देखा जाएगा, क्या रिक्वायर करता है क्लोजर के लिए। Notice of closure has to be given to the state government in Form Q. Form Q भी उसमें provided है, तो अब कोई भी इंडस्ट्री ऐसे आप एक बैग नहीं क्लोज कर सकते। आप if you want to close, you will have to give intimation to the state government that you are going to close. और एक 76B भी देख लिया जाए।
there is a prescribed procedure.
हाँ,
दरवाजा बंद करके क्लोजर नहीं होता।
हाँ, एक बैग आप लोग चिपका दिया नोटिस और खत्म हो गया। और इसी लगातार में रिट्रेंचमेंट के लिए रूल 78 भी देख लिया जाए उसमें। बस ये 3 रूल के ये 3 प्रोविजन है। उसमें भी कहता है कि स्टेट गवर्नमेंट को आपको नोटिस देना होगा फॉर्म पी में।
नहीं तो 25F का वायलेशन हो।
हाँ तो 25 हम आ गए सेक्शन पर। अभी केवल हम रूल का ये इनका रिक्वायरमेंट डिक्लेयर देना चाह रहे हैं। अब बिफोर मेकिंग एनी फर्दर आर्गुमेंट एक पैराग्राफ के लिए वार्ड का हम दिखलाना है, उसके बाद फिर हम प्रोविजंस पर आएंगे। स्टैट्यूटरी प्रोविजन ये वार्ड का एक पैराग्राफ केवल देख लिया जाए, पेज 58। पेज 58 में पैराग्राफ 6 हम वही पैराग्राफ फर्स्ट पैराग्राफ पढ़ेंगे। इन दिस केस द मैनेजमेंट हैज एग्जामिन्ड ओनली वन विटनेस एज MW1 श्री तरुण कुमार बसु। MW1 हैज स्टेटेड इन हिज एविडेंस दैट ही वाज वर्किंग एज मैनेजर अकाउंट्स इन द कंपनी which was closed by notice of closure and had supported the case of the management. बस इसके बाद वाला जो है उसी पर हम रिलाई कर रहे हैं। But the management did not produce him later for cross examination and hence his evidence was expunged by the order of the court. The management has not filed any other documents in this behalf. अब इसमें ये क्वेश्चन राइज करेगा, पहला क्वेश्चन कि मैनेजमेंट की तरफ से तो कोई एविडेंस ही नहीं है कि whether they have complied the provision of the law, तो whether the closure was justified or not. This will be the first question because there is no evidence at all on their behalf. There cannot be any presumption. ये मेरा पहला एक सबमिशन हुआ और इसी पर इंटायर अदर सबमिशंस भी आ जाएंगे। जी
आप कंटिन्यू करिए।
नहीं हम पढ़
नहीं,
समझे कि
हम
आप
तो
पढ़ रहे हो
साथ-साथ
तो उसमें
हम साइमल्टेनियसली देखते हैं।
अच्छा
You just continue.
then my lord, so far the closer part is concerned, the statutory provisions are section 25 FFA, all capital. आप पढ़ने लगती हैं तो हम थोड़ा
नहीं, हम साइमल्टेनियसली पढ़ते हैं। मल्टीटास्किंग की मेरी आदत है। चिंता मत
नहीं, थोड़ा लगता है कि ध्यान उधर है, इस समय डिस्टर्ब करना ठीक नहीं है।
उतना तो हम पढ़ के ही आते हैं।
25 FFA, 60 days notice to be given of intention to close down any undertaking. An employer who intends to close down an undertaking shall serve at least 60 days before the date on which the intended closure is to become effective a notice in prescribed manner, तो उसी के लिए रूल हो गया, prescribed manner on the appropriate government, stating clearly the reason for intended closure of the undertaking. There is a proviso also. They provided that nothing in this section shall apply to an undertaking in which less than 50 workmen are employed or less than 50 workmen were employed on an average per working day in the preceding 12 months. An undertaking set up for the construction of the building, bridge, road, canal, dam or other construction work. So इसमें ये exemption में आता है कि नहीं, that should have been stated, but there is no evidence on behalf of the manager.
टोटल तो 11 वर्कमैन है ना।
हाँ, इसमें 11 वर्कमैन है, डिमांड 11 वर्कमैन को से था।
क्लोजर का भी ग्रीवेंस सिर्फ 11 ही वर्कमैन का।
हाँ, वह डिमांड और क्लोजर 11 ही वर्कमैन। But actually there is no material to show that how many workmen were working. Then 25 FFF is there. Compensation to workmen in case of closing down of undertakings. Where an undertaking is closed down for any reason whatsoever, every workman who has been in continuous service for not less than 1 year in that undertaking immediately before such closure shall, subject to the provisions of subsection 2, be entitled to notice and compensation in accordance with the provisions of section 25F. This will take us to 25F, but I want to complete this section before going to section 25F. As if the workman had been retrenched, तो क्लोजर को retrenchment के साथ कंपेयर कर दिया गया, कनेक्ट कर दिया।
क्लोजर अगर इन अकॉर्डिंग विद लॉ नहीं होगा तो इट विल बी ट्रीटेड एज रिट्रेंचमेंट एंड देयरफॉर रिट्रेंचमेंट कॉम्पेंसेशन इज पेड।
जी हाँ, वही हम दिखाना चाह रहे थे। So, my lord, I am trying to assist, my lord. I may be little longer, but if lordship kindly pardon, my lord, I just want to. So it takes us back, my lord, to section 25. 25 what says? 25 says condition precedent to retrenchment of workmen. No workman employed in any industry who has been in continuous service for not less than 1 year under the employer shall be retrenched by that employer until the condition, this will be the condition precedent, until the 3 conditions have been given. The first condition is until the workman has been given 1 month's notice in writing indicating the reason for retrenchment. The reason is totally absent, reason for retrenchment and the period of notice has expired, or the workman has been paid in lieu of such notice wages for the period of the notice. Then the second condition is the workman has been paid at the time of retrenchment compensation which shall be equivalent to 15 days average pay for every completed year of continuous service or any part thereof in excess of 6 months. And the third is notice in prescribed manner is served on the appropriate government for such authority as may be specified in the appropriate government in the notification in the official gazette. These all facts, my lord, were required to be brought by the management, and management has failed to show that they have complied provisions of section 25. So these were, my lord, so far, my lord, the closer part is concerned. So far retrenchment is concerned, I have already pointed out to your lordship, my lord, this rule 78 in the rules, that it also requires the notice in form P to the state government that that nothing has been done. Section 25A is also, I have already pointed out. Then section 25G and N. G and N has to be seen. Section 25G and 25N. Where any workman in an industrial establishment who is a citizen of India is to be retrenched and he belongs to a particular category of the workmen in that establishment, in the absence of any agreement between the employer and the workman, in this behalf, the employer shall ordinarily retrench the workman who was the last person to be employed in the category, unless for the reason to be recorded the employer retrench any workman. So this again, the management has brought, has failed to bring any material that they have complied in 25G, and 25A is the punishment. 25 condition precedent. That is condition precedent.
F is also dealing with condition precedent to retrenchment of workmen, and 25N is also dealing with.
Also,
what is the difference between the two?
Well, the 25H so far it relates to the separation, that part, and the 25N Miller, that is the separate, that 25F is in relation to management and workmen only, and intimation to the state government. But this 25N requires further action on the part of the.
So what is the difference between these two sections? Because it is both the sections are dealing with the condition precedent to retrench the workmen. You see, the first is absolutely the same, almost, right? For not less than continuous service of 1 year. Then what is the difference between the two? Why this 25N is separately introduced? What is the purpose of having a separate provision for 25N? This is in relation to closure.
25N is no.
Why was 25N required?
No, I'm sorry. I apologize. I apologize.
This is layoff, retrenchment, and closure in certain establishments.
No, 25N is not applicable. I'm sorry. I'm withdrawing that. That is in relation to some special type of industry.
Yes.
It is not applicable. 25N is not applicable. I'm sorry.
25G is also not applicable.
No, 25G is also. 25G will be applicable. N will not be applicable. 25N will be for a special type of industry.
Yes, that is a separate provision altogether.
A separate one. 25G will be.
This is a procedure for it.
Yes.
That is a separate one.
Separate provision, separate type of industry, and a separate type. So, in the background of the fact now.
So we are concerned with these sections 25F
Continue.
and section 25F, FA, and then rule 76A,
76A and 76B and rule 78.
6B and 78. These rules are under which section?
Yes.
'78 is these are the provisions which we are concerned.
ये जो these are the provision. ट्रिपल एफ हो गया ना?
हाँ, triple.
डबल एफ है, ट्रिपल एफ, 25F, and then 25 of procedure for 25 O.
25 triple F, 25 double F A.
हाँ.
अब बताइए.
एक the rules, but at 25. Now coming back, to the fact that there is no evidence on behalf of the management in support of the action taken by them, whether they have taken any action in compliance for the compliance of the provision, and then the two findings which the Labour Court has recorded, that whereby they have put the onus on the workmen to establish the case. So that they have committed error of record.
That's all.
Yes, madam, that's all. So one judgment, if you not say, of course, that is not of the Supreme Court, but in such a situation, it was in relation to Badarpur factory that was in Delhi. That is the judgment of the Delhi Millard. Of course, Millard, it is on section 25 for consideration. Millard, I cannot say that it is binding. In this case, due to non-compliance, the High Court has remanded back the matter and directed for calculation of the proper compensation that the Lordship can
Your specific case was there were 11 workmen.
हाँ 11% जी.
No, even as per the notice which was pasted on the door,
जी.
only 11%.
11% इस बात का कहीं हमने तो एडमिट किए हैं अपने डिमांड में कि we accepted the money which was there, but they have said it was a less amount, it was not the complete amount, not in accordance with law, and they are.
So what was your prayer before the labor court?
The labor court
Your
turned down.
written statement is there on record.
Pardon me.
Your written statement is there.
Yes, that is annexure. Written statement is there. If you not, I have not drawn your lordship attention to that, my lord. A written statement, my lord.
Para 29.
My lord. A written statement of the workman, your lordship may can see. Paragraph 3, paragraph पढ़ देंगे अभी, मगर नोट करा देते हैं पहले. 3, 4, 6 to 11, 18 to 21 and 25. ये है annexure 2, page 36. और मैनेजमेंट का भी रिटर्न स्टेटमेंट है. That is annexure 3.
29 भी देखिए.
जी. Pardon नहीं हम.
Para 29 भी है.
मैनेजमेंट का.
आप
मेरा 47.
You were claiming continuity in service.
हाँ कंटिन्यूटी सर्विस क्लेम कर रहे थे.
मैनेजमेंट की तरफ से तो कोई एविडेंस नहीं आया.
जी नहीं तो दिखला दिए, इससे शुरू में ही दिखला दिए कि हमारा बर्डन कम हो जाए आप जाए.
इन लोगों ने प्ली लिया था अदरवाइज कि दैट द क्लोजर वाज इन अकॉर्डेंस विद सेक्शन
हाँ
25
जी.
That's all. Yes, Mr. Mishra.
In case of any need, I am here to reply.
Where is Mr. Mishra? वो चले गए. कहाँ चले गए भाई इनको? फोन करिए भैया. इनका कोई जूनियर को तो रहना चाहिए ना कोर्ट में.
हमने दूसरा और दिन तो कोई थे रहते थे.
प्रोसीडिंग छोड़ के चले जाने का ऐसा कौन सा?
Proceeding just some general explaining.
आपको क्या बोलना है?
Actually, I'm referring to paragraph 8 of the memo. 8 of the memo.
पढ़िए.
On recruitment and on careful consideration of moral and documentary evidence used by the parties, it is undisputed that this case disputed that the concerned workmen were not employees of the process to staff and limited the thankful and the office of the defendant. But they had not covered the shop. Now this workmen are pleaded. And the management has disclosed the industry company and also put in any notice of the management has paid notice paid and compensation according to law to the concerned workman have detailed and stated that they have received the compensation amount after the closure of the compensation amount with the consent about full and final payment and left the company whatever. Thus, it is not a case of termination of service, and this case is liable to be dismissed. And they have also not workmen of their capital, or with their restrictions are there. The company as a whole has not been closed. The particular unit has been. That is the first point. The second is that the closure of the unit or the company because of the litigation that it become unproductive. There were a lot of litigations, so that it has to be closed and you are not there. You are the level of concerns are not there. It has not evidence. So this company, this unit, particular unit was other sections, relevant sections. In fact, my submission does not contemplate a partial closure of a particular unit. And then the payment is made with consent without protest. That is the significant fact. So now the whole question, 25 and FA, whatever, it is a consented agreement, payment made, and thereafter no activity will be. But this is to be distinguished from the finding that this particular finding has not been assailed in the application or for doing it. That is the primary point. And the other allegation that they were still continuing with the employment technical questions, that is also not substantial. That's why, that is the reason why the lower court has not gone into the question of 25 and other sections. But it is a unit, particular unit with consent, just closed down the work. And
From where do we get the consent? Consent कहाँ है? Where is the consent for closure?
that is the money received.
Money received amounts to consent
That is without protest.
without protest.
Without protest, that is the finding.
When was the money received?
Yes,
When was the money received?
that your responsibility is not on the management, but it is admitted that the workman has already received the amount.
When was it received?
That I am not able to bring because I don't have the records of the what is not categorical. But because sometimes it may be from the date of the closure that 8, 9 and 10 December. That is the same paragraph.
Why different proceedings were pending? There were different cases pending.
In fact, my lord, what has happened?
There were number of cases pending.
Yes, it appears that the management was not very fair to the work, and that's why they were creating a lot of difficulties, my lord, so that they leave the work. Suo moto leave the work, and that's why first they transfer from one workman to a different place, then departmental action. So all less payment, not proper payment. These were the.
Did you accept the payment without protest?
No, my lord, immediately, my lord, on protest. on protest because my letter of demand clearly indicates. हम हुजूर को पेज 34 में पढ़ के सुनाए हैं.
That's right.
हाँ, yes. Immediately जिस दिन हम लोग जब बंद पाए उसी दिन ठीक.
There is a statement in the written statement that you accepted the payment on protest. Is there any statement mentioned?
हमारे भी स्टेटमेंट में है.
Written statement.
दिखला देते हैं.
Para number 23, you say that the amount was not appropriate.
हाँ,
It is not your case that you accepted the payment on protest
नहीं.
in the written statement.
एक मिनट. मतलब पैराग्राफ 19 में 19
Yes.
पैराग्राफ 19 पेज 42. That since the services were terminated and since the resolution of the dispute arising out of the illegal and malified closure, consequent retrenchment was likely to take time, union and vice the workmen to receive under protest the retrenchment compensation to save their families from starvation.
This letter which you have annexed along with the, which was a part of the Reference.
Notification making reference.
yes. This letter has two dates. One is September 9th, 1997, and in the next date it is 31/10/1998. Next page, page 35.
जी हाँ,
31/10/1998.
एक मिनट. जी हम है तो मगर I'm not in a position to explain it just now. But the reference was made on the basis of letter dated 9/9/96.
It has a date,
हाँ जी हाँ,
but
date.
signature in the year 1998.
It appears that it was served on the management by Lord. Probably because Blue Star employees नहीं not in a position. नहीं बता सकते.
लिखिए. For the learned counsel, Mr. VPC, senior advocate, appearing on behalf of the petitioner. Your name, please, madam.
वंदना भी थी सर, वो जो उसके दूसरा कोर्ट में देखने के लिए भेजे. वंदना
बिना appear हुए हैं.
अच्छा नहीं.
Along with MS Ragini Kumari. Word Mr. G.M. Mishra, learned counsel appearing on behalf of the respondents who has joined the proceedings online. The learned counsel for the petitioner. has referred to the
एक बात क्लियर करना चाहता हूँ, एक मिनट. The workmen also were interested that they may be absorbed on the other units. It was a closure of unit, not of the entire organization. As Mr. Misra has also said that it was a closure of a unit. So action of the management on that line was also cannot be said to be justified. They could have, if they were going to close one unit, they could have adjusted the workmen at a different units also. ये हम केवल करना बस.
the learned counsel for the petitioner has referred to the terms of reference and has submitted that a letter dated 9/9/1997 was an enclosure to the terms of reference. The enclosure to the terms of reference has also been annexed along with the writ petition as contained in page number 34, and he has referred to the statements made therein to submit that the vice president of the respondent company was duly intimated that the required procedure was not followed, and one fine morning on September 8, 1997, they found that the unit was locked. He submits that through the said letter it was intimated that the amount mentioned, the check/draft which was offered by way of final dues/settlement was accepted by the employees on protest. A list of 11 workmen was mentioned in the said letter dated 9th of September 1997. He has referred to the provisions of section 25 FFA, 25 FFF and 25F of the Industrial Disputes Act to submit that if the closure is not as per law, then the provisions of section 25F is attracted, and the employees who have been retrenched on account of closure are entitled to compensation in terms of section 25F. The procedure for closure was not followed, and accordingly the same cannot be said to be, it cannot be said that the unit was closed down as per law. For the purposes of closure of unit, the learned counsel has also relied upon Rule 76 capital A, 76 capital B and 78 of Bihar Industrial Dispute Rules to submit that the rules have force of law and there are statutory procedure to be complied prior to closure. He has further submitted that the case was virtually without the evidence on the part of the management, inasmuch as the management witness did not appear for cross-examination. The learned counsel has submitted that the learned court has gone into the point that the compensation amount was accepted without protest and has passed the impugned order. Impugned award. The learned counsel has submitted that the protest was mentioned in the letter which was enclosed to the terms of reference. he has also submitted that the unit that the respondent had different units, and in case one or the other unit had closed down, the workmen ought to have been adjusted in other units. Even such step was not taken, and therefore there has been violation of provisions of section 25F/25FFF/25FFA of the Industrial Disputes Act, and therefore and consequently the award passed by the learned court is to be set aside. During the course of hearing, the learned counsel for the petitioner was asked to explain a different date which is appearing in page number 35 of the record, that is 31/10/1998. Although on the previous page the date of letter is mentioned as 9th of September 1997, the learned counsel has submitted that he has no instructions with regard to this mismatch in the date between page number 34 and 35. However, he submits that the fact that the amount was received under protest was raised by the workmen in paragraph 19 of the written statement. In paragraph 23 of the written statement filed by the workmen, a plea was raised that the compensation paid was not in accordance with law and it fell short of what was legally. The learned counsel, appearing on behalf of the respondent, has submitted that, has referred to paragraph number 8 of the include award to submit that the learned court has taken the materials into consideration and has come to a conclusion that the compensation was received with free consent towards full and final settlement, and thereafter the workmen had left the company, and consequently it was not a case of termination. He has submitted that the award passed by the learned court does not call for any interference, as findings have been arrived after considering the materials on that one. That's all. Arguments concluded. Judgment का डेट दीजिए, फरवरी 1 का डेट दीजिए। ये जो रूल्स है ना आपके, इसको थोड़ा सा हम आ गया, ये रूल्स आ गया है, ये है ना, इनको वापस करिए, किताब इनका बहुत प्रेशियस किताब है,
तो बहुत दिन से अवेलेबल नहीं है सेपरेटली, जल्दी मिलता नहीं।
इस किताब में है सर, लोकल लॉज।
हाँ ठीक है, लोकल लॉ हम नहीं लिए हैं।
किस में डेट है?
4 जनवरी की है,
2 फरवरी की,
4 जनवरी,
4 जनवरी नहीं, फरवरी फर्स्ट वीक,
सॉरी 4 फरवरी,
ना उसी दिन से। ठीक, अच्छा, इनका जो है 8 to 11 है, ठीक, ठीक। He has submitted that altogether there were 11 workmen. 11 workmen है ना? ठीक, ठीक।
वो पैराग्राफ 19 के बारे में लिखा गया है, अंडर प्रोटेस्ट व्हाट्स हैव प्रोबेबली शायद छूट गया है। पैराग्राफ 19 के बारे में बोलिए जज। पैराग्राफ 19 रिसीव द अमाउंट ये है
इससे अंदर प्रोटेस्ट ही लिखा है।
दिखाया है खाली हमको। आई एम सॉरी
नहीं, वैसे हमारे यहाँ सारा कुछ हम लोग पैराग्राफ चेक करके ही टाइप करते हैं।
ठीक।
कुछ अगर वर्ड छूट भी जाता है तो हम
तो
लोग
आ
डाल
जाए।
देते हैं इसको।
ठीक।
जब किसी पैराग्राफ को रेफर करते हैं तो उसके कंटेंट को हम लोग ध्यान देते हैं कि वो सही से टाइप। कभी कभी छूट जाता है बोलने में, हो ही जाता है। जब पैराग्राफ को रेफर करेंगे तो वी विल चेक।
ऑनरेबल जज से कभी मिस्टेक की बात नहीं है।
नहीं, हो ही जाता है, ऐसा नहीं है। डिक्टेशन में कभी पैरा 19 का जहाँ रेफरेंस है लिखा हुआ है ना।
ठीक है।
Submits that the amount was received under protest.
Oh, I'm that. I'm sorry,
और हम लोग कभी कंफ्यूजन होता है तो रिकॉर्डिंग से भी चेक कर लेते हैं। आप एकदम निश्चिंत रहिए इससे। और इसीलिए एडजर्नमेंट ऑर्डर्स अपलोड भी करते हैं।
नहीं वो तो
सारे एडजर्नमेंट ऑर्डर्स होते हैं ना अपलोड। आर्गुमेंट कंक्लूडेड वाले ऑर्डर्स भी अपलोड होते हैं।
But I tried to mail it to.
नहीं, ठीक।
All right.
Fourth February.
Fourth.
The least I can do for the litigant is कि कम से कम जो बहस हुआ हो उसको रिकॉर्ड करें और उसको अपने तरफ से डील
Decision,
करें।
nobody can. That decision.
कम से कम ये ग्रीवांस किसी को नहीं होना चाहिए, ये बहस किए डिसाइड नहीं हुआ, इस तरह का ग्रीवांस बहुत सीरियस हो जाता है। नॉट गुड फॉर द सोसाइटी एट लार्ज। इसका मैं विशेष ध्यान रखूँ।
Not good for the institution.
Orders with effect item 2, WPC 2582 of 2017.
The defects were but these number 17 and 18 that I have seen right now, that the certified copy is required to be. That I have to obtain requires time.
17 and 18 का तो डिफेक्ट पहले से ही चल रहा है।
अभी हमने देखा और some of the defects I have filed a certified copy of the documents which were
आपका एक बार डीएफटी हो चुका है।
हाँ, certified copy फाइल हुआ उसने बोले कि नहीं टाइम इज ओवर, but they have accepted the certified copy, but said that the time is over therefore.
WPC number 2582 of 2017.
Number 17 and 20, I will not ignore it.
Ignore नहीं कर सकते। The learned counsel for the petitioner prays for and is allowed। कितना दिन में कर देंगे?
For it's a old order, that is not 12 order I have to have.
कितना दिन आपको चाहिए?
4 weeks.
Is granted time till 24th of January 25 to remove the surviving defects present. If the defects are removed within time, pose this case on 29th of January.
Item 3, CMP 70 of 2024.
Because there is one IA for substitution matters. The original WPS was dismissed matters for non-removal of defect matters. Subsequently, restoration petition has been filed matters. However, one of the petitioner has died and the wife of the petitioner has filed the present CMP matter. So there is one IA for substitution of petition number 5 with the present petition number 3 matters.
देखिए CMP number 70 of 2024 with ID number 12311 of 2020. Counsel for the petitioner submits that the writ petition being WPS number 2951 of 2019 stood dismissed for non-compliance of order dated 25/4/2022. However, during the pendency of the writ petition itself, the petitioner number
5 in WPS.
5. In the writ petition had expired. The death certificate has been placed on record. The date of death is 24/4/2021. He submits that the interlocutory application has been filed
There were total 11 petitioners ballots in the original WPS. 8 has preferred this restoration petition, out of which the petitioner, the IA has been preferred on behalf of petitioner number 3 in the same.
the wife of the original petitioner number 5 of the writ petition is petitioner number 3 in this petition, in the petition for restoration, and office has pointed out that the defect with regard to petitioner number 3, as her name does not find place in the cause title of the writ petition. He submits that the defect in connection with petitioner number 3 be ignored, and she may be permitted to pursue the present application for restoration. The learned counsel has submitted that the petition for restoration has been filed by all the petitioners in the writ petition except
But only 8 of the petitioners have preferred, others have been made performer respondents here.
कौन फाइल किए हैं? Okay, has been preferred by only 8 of the writ petitioners, and the others have been made pro forma respondents. Considering the aforesaid submissions, IA number 12311 of 2024 is hereby allowed, and the office defect in connection with petitioner number 3 in the present case is ignored. Okay?
There was one defect related to the non-payment of advocates' welfare fund that has been deposited, and this is the receipt.
The learned counsel has submitted that he has removed the other defects. Office to check, pose this case on 3rd of January under appropriate.
Online.
There is Judge.
Orders item 4, courtesy 1492 of 2015.
There is an office note that 80 of the notices issued have been received but is not found, missing from the record.
You take precedence. WPC number 1492 of 2015. Counsel for the petitioner is directed to take fresh steps for service of notice upon respondent number 4 let the notice be issued to respondent number 4 through the concerned police station. Through the concerned police station. The requisites be filed by Friday. By Friday. आप ले लीजिए, आपको कॉपी तो मिला हुआ है?
नहीं 2015 में तो 2018 से तुम तो बाकी 2019 से
दे दीजिए आप. Pose this case on 24th of January of the service.
Item 5, WPC 5501 of 2015.
Yes, petitioner.
Your Ladyship, we are receiving the order dated 14/7/2015. That is annexure 5, page 47. By which our application under Order 1, Rule 10, Clause 2 has been rejected. This application is under 227 of the Constitution.
For implement.
Yes.
What is the status of the suit?
That I have to contact the
There is no stay.
status of the execution proceeding or the miscellaneous application, miscellaneous proceeding. Because we have filed an application in the miscellaneous proceeding.
Okay. There was an order of stay passed by this court way back on 12/4/2016. Notice of who? You wanted intervention?
Yeah.
How intervention?
Because the vendor, my vendor was the party to the suit. The suit was decreed in his favor. I purchased the property in 2013 itself.
When?
After the disposal of the suit.
So?
Now the respondent herein has filed an application to setting aside the ex parte decree. And the original vendor, my vendor, the decree holder is not contesting in that particular proceeding. Therefore, I filed an application in it.
I was playing for 1 week time on behalf of whoever. He told me that client has taken back the brief. Whether he has filed an NOC or not, I cannot say.
Wakalatnama is there, Mr. Abhay Prakash?
No, client has taken back the file. Whether he has filed, we will still.
No, he has not filed any fresh Wakalatnama. He is not interested. It's a very simple case. He is the successor in interest and there is a petition for setting aside the ex parte decree. So now the person who has sold the property is not interested. So बेच के चला गया. Who will contest?
No, see, they have taken back the file. Therefore, I was praying for one time to say whether they are interested. Because I don't have any instruction.
WPC number 5501 of 2015. Counsel for the petitioner is present. He submits that the petition seeking intervention has been rejected. Although the intervener was the successor in interest of the property, and now there is a proceeding for setting aside ex parte decree. The vendor of the petitioner is no longer interested in the case, and the rights of the petitioner is going to be ultimately affected. And therefore, he has a right to be heard. The learned Mr. Pura naam बताएं please.
Shushavan Bhaumik.
Mr. Shushavan Bhaumik submits that he has been informed by Mr. Abhay Prakash, advocate, that the client has taken the brief from him, but 1 week time may be granted so that the respondent may take appropriate steps in this case. Oppose this case on Tuesday. Next Tuesday in the supplementary cause list. इसका जरा पता कर लेंगे miscellaneous appeal का status पता कर लेंगे मुझे. The counsel for the petitioner is also directed to inform this court about the present status of miscellaneous case number 3 of 2014.
No, because it has been stayed by.
We do not know because बहुत सारे cases में stay automatic vacate हो गया है. There are many things which might have happened. So you just let us know. वो लिस्ट पेंडेंस का एक सुप्रीम कोर्ट का जजमेंट नहीं लेके आए हैं.
because it will not apply in my case, Your Ladyship, because I purchased the property after the disposal of this one.
So there is a judgment on this that the
I
aggrieved
will-
party.
So they,
Are you aware? Not aware.
I am. There is a judgment.
जजमेंट नहीं लेके आइएगा तो क्या ही ऑर्डर करेंगे.
Item 6 WPC 468 of 2016.
There is a judgment, no, that intervention is to be allowed when the party is not interested in the matter and he has sold off the property. Maybe that new written statement he cannot file, but he is to be heard, isn't it?
Yesterday only I argued to matter similar matter in court number 9. This was once a party is impleaded, once a person is impleaded as a party in the civil suit, it is incumbent upon the plaintiff to amend the plaint so that the other party who has been impleaded can file a written statement. Unless a written statement is filed, he won't be allowed to lead evidences. So on this logic, Malas, so the query of this court, Malas, there is a withdrawal judgment, Malas.
There is a direct judgment on this.
Yes, I remember that, Malas. So
That if the person, you see, the successor in interest has come into picture, the predecessor in interest has no interest in the case. He will not even pursue the case. Maybe that the successor in interest will not be in a position to file a fresh written statement, but he may have something or contradictory statement he cannot make.
yes.
But he has got a right to be heard.
Yes, definitely.
Just like after the death of a person, when legal heirs are impleaded, they may file something in the court, but they will not be permitted to take a contrary stand, whatever stand has been taken in the written statement.
For that, leave of the court is necessary. That there is
Yes,
for
so
that
there is a judgment on this. I don't remember exactly.
If permitted, I can
Somebody had cited it here.
If
I don't.
permitted, I can produce the judgment on Monday.
हाँ वो दे दें.
हम ला के दिखा दें.
हाँ बताइए. आपके सीनियर कौन है?
राहुल कुमार गुप्ता.
उनको तो सारे ही जजमेंट्स पता होंगे. I don't know. चलिए.
इसमें मुझे instruction है to withdraw this petition.
Item 6.
WPC number 468 of 2016. The learned counsel for the petitioner, Mr.
Praveen Akhare.
on instruction seeks permission to withdraw this petition. Permission is accorded. The petitioner's business has withdrawn. Any interim order passed?
Yeah, there was order of stay. I remember.
सब interim order सब vacate कर देंगे, stay put कर देंगे.
Sign कर.
Item 7 WPC 1756 of 2016.
Yes, ma'am. One IAS certification. Who has expired when?
Who? Hari Lora. Hari Lora.
Hari Lora has expired on 19/10/20. Who are the legal heirs?
21/3/2020. 21/3/2020.
1910 लिखे.
No, my ladyship, it is 21/3/20.
21/3/20. वकालतनामा फाइल किए हैं. Who all are the legal heirs?
Paragraph 3, my ladyship, to son.
Any objection? Private respondent? Any objection? Do you have any objection to? IA number 2400 of 24 in WPC number 1756 of 2016. The learned counsel for the petitioner has submitted that petitioner number 1, namely Hari Lohra alias Hari Kashyap, son of Akul Lohra, has expired during the pendency of this case on 21/3/2020. The interlocutory application is for substitution. The details of the legal heirs and successors has been mentioned in paragraph 3 of the interlocutory application. The learned counsel for the respondents have no serious objection to the prayer for substitution. After hearing the counsel for the parties and having gone through the interlocutory application, IA number such and such is seeking substitution of petition number 1 is hereby allowed. The counsel for the petitioner is directed to carry out the necessary amendment in the cost title in reading during the course of the day. It is made clear that the substitution has been allowed only for the purposes of the present case and no more. सक्सेशन नहीं डिसाइड किए हैं यहाँ पर, और बाकी कब करेंगे आप? आइए तो डिस्पोजल हो गया, आगे
जनवरी में।
कौन सा जनवरी?
25 में।
2016 से तो चल रहा है, 2026 जनवरी में फिक्स कर देते हैं, पूरा एकदम 20 साल कंप्लीट, 10 साल, 20 साल नहीं 10 साल। हाँ, आप किनकी तरफ से हैं? 71A
is against the restoration case. The land has been restored in favor of private respondent who filed.
इनको कहाँ ही चिंता है कि इनको जमीन चाहिए? क्या केस है? Prima facie भी?
Prima facie
in all the courts they have lost.
They have lost.
What is the reason for?
Reason for they have obtained the land by a sada sale deed.
The petitioner.
The petitioner, and which the veracity of which could not be proved. And violation of section 46 of the CNT Act also. There was no permission.
So both of them are tribals?
Both of them are tribals, but section 46 envisages that the tribals must be from the same district, Thana.
What is the date of
and
disposition?
And prior permission of deputy commissioner is there.
Date of disposition?
Date of disposition is 2016 was the order of the revision petition validation.
Dispossessed for more than 30 years. Limitation deal किया है?
Limitation is
dealt with.
We have the state has taken the ground of limitation as well.
कौन करेंगे आपका केस?
ये सीनियर राजन साहब। राजन साहब।
मिस्टर आर्यन साहब।
राजन साहब।
राजन साहब। तुमका नहीं जानते हैं? जानते हैं? हो सकता है देखेंगे तो पहचान जाएंगे। Pose this case under appropriate heading on 7th of January.
Item 8, WPC 4022 of 2016.
Yes, petitioner.
Citizens' notices have been served, madam. The respondent number 2, 4 and 5 have appeared, and to respondent number 11 notice has been served. With respondent numbers 1, 3, 6, 7, 8, 9 and 10, they were not found at the address place.
Has come up for orders.
Yes, ma'am.
You take appropriate steps, get it published. We do not know what steps you will take. It's a suit?
Yes, madam. It's a suit. It had gotten awaited, madam. Because we could not substitute the respondents, madam. It had gotten awaited, madam.
So, what relief can be granted? If it is awaited.
Yes, madam. We had filed a petition first, madam, to set aside the abatement, and then in that one condition had been given to pay 1,500 rupees and then substitute, yes, my lords. In time we were not doing it, my lords. But then later we took steps to submit the money, and then, but still that pension is also set aside, and that's why we have filed an appeal under Order 43 Rule 1K, my lords, to set aside the abatement. But that was rejected, stating that earlier you had already gotten an opportunity and you didn't avail that, and you didn't submit the fee on time, that's why.
You are for the private response?
For respondent number 2, 4 and 5.
WPC number 4022 of 2016. As per office note, the notices could not be served upon respondent number 1, 3, 6, 7, 8, 9 and 10. Respondent number 2, 4 and 5 have already appeared. Respondent number 11, with respect to respondent number 11, the notice has been served upon his wife, which is accepted as valid. Counsel for the petitioner prays for time to take appropriate steps in connection with respondent number 1, 3, 6, 7, 8, 9 and 10. Post on 3rd of January. Either you gather the present and correct address. The suit must be pending.
It's gotten abated.
The suit itself has been now disposed of. Either you get present and correct address, or you file appropriate issue for substituted service.
Item 9, WPC 806 of 2017.
As per office note, respondent number 6 has expired. स्टेटस रिपोर्ट आया है, नो स्टेटस, ये स्टेटस रिपोर्ट आया है और फ्लैग आर the office is directed to call for the status report of the suit of civil appeal number 19 of 2016 from the Court of Principal District and Sessions as Jamtara. Let this order be communicated to fax. इसको जरा nobody appears for the petition. Post on 9th of January.
Item 10, the rupees is 4127 of 2018.
My lords, in this case, notices were issued to respondent 5/2/31. Out of them, my lords, 14 appeared and filed Vakalatna, my lords. My lords, tracking report shows that respondent 12 and 13 were not found at their places, not residing in the village Belgama. So, I may be permitted to file requisites in fresh address, my lords, upon respondent number 12 and 13. And so far as respondent 14, 15, 16, 20, 24, 28, 29, 30, 31 is concerned, the speed post has been sent to the branch office, my lords. And so far as the respondent number 10, 14, 16, 20, 24, 28, 31 is concerned, undelivered speed post has not yet been received. So, fresh notice may kindly be ordered to be issued on these respondents or for other respondents where a final report has not come. Your lordship will be passed appropriately.
Your Ladyship, I am appearing for respondent number 17, 18 and 19.
And I am appearing for 5 to 9 and 11, Your Lordship.
WPC number 4127 of 2018. Learned counsel for the petitioner submits that he may be permitted to take fresh steps for and is permitted to take fresh steps for service of notice upon respondent number 12 and 13 at their present and correct address. So far as other respondents bearing me, the respondents number 10, 14, 15, 16, 20, 24, 28, 29, 30 and 31 are concerned, the service report is not available, although the notice was sent through speed post.
21, 22, 23 and 25, 26 and 27.
क्यों आप बोल रहे हैं? आपका नंबर बोले क्या? Let notices be issued upon respondent number 12 and 13 at their present and correct address, and upon respondent number 10, 14, 15, 16, 20, 24, 28, 29, 30 and 31 at the address given in the writ petition. कहाँ के हैं सब लोग?
ये सब दुमका के.
Let the notices be served through the concerned police. ऐसे नहीं होगा जब तक जाके वहाँ पे कोई पुलिस वाला नहीं जाएगा, इन लोगों को कुछ समझ में नहीं आने वाला. ठीक है? The requisites be filed by the petitioner by 3rd January. 3rd January तक रिक्विजिट फाइल कर दीजिए सबका.
4 weeks दे दिए.
4 weeks नहीं हुआ क्या?
पूरा रीड उसको पूरा ज़ेरॉक्स.
ठीक. By 24th January. Pose this case on 28th February, 20 फरवरी. Awaiting service report.
Speed post.
आप यहाँ पे रिक्विजिट फाइल करिए, थ्रू द कंसर्न पुलिस स्टेशन जाएगा कोर्ट से.
Item Item 11. Contempt civil filing number 12783 of 2024.
Is there an objection on the point of maintenance? There is an office objection on point of maintainability.
Okay.
4 writs were disposed of by the common order. This was because there are 4 petitioners and 4 writs were filed. They were all belonging to the same family. This is regarding a rehabilitation compensation matter. Thereafter, your leadership was pleased to pass specific directions in para 9, directing us to file a joint representation. Thereafter, a joint contempt has been filed by them here. Office objection is that with regard to the joint contempt petition, that because they have filed together, the 4 petitioners have become the petitioners here in the contempt. The contemner, the proposed contemner is also DC Chatra, that is common. And your ladyship's direction in para 9 is also by a joint representation, we have to make a representation.
Contempt civil token number 12783 of 2020. The counsel for the petitioner submits that 4 writ petitions were disposed of by common order, and all the writ petitioners were belonging to the same family, and they were supposed to file common representation. He submits that 1 petition for contempt has been filed, and the office has raised an objection that 1 petition could not have been filed as 4 different writ petitions have been disposed of. He submits that such objection be ignored. बताइए कुछ बोलना है आपको objection है?
नहीं.
The learned counsel for the state has no serious objection with the prayer of the petitioner seeking to ignore the defect as pointed out by the office. Considering the aforesaid submissions, the office defect in the aforesaid respect of the matter is ignored. For the present. अब बताइए आप शो कॉज फाइल करिए. Let this matter be posted on 24th of January. In the meantime, the learned counsel for the state is directed to seek instructions from the opposite party number 2 or his successor in interest, and file a show cause or compliance.
Office filing item 13, WPS 6291 of 2024.
Yes, petitioner. Petitioner.
Yes, sir. In this case, my very limited period is for keeping in abeyance the Section 1, because during the pendency of my statutory appeal, the recovery proceeding had been initiated and notices had been issued. So we have filed an appeal and our appeal is pending. So only the breathing time till my appeal is heard, this Section 1 may not be executed.
आप अपील में जाइए ना.
अपील फाइल किया हुआ है मेरा.
क्या हो गया अपील में जाइए?
Appeal because the presiding officer is not holding court.
नहीं अभी आ गए हैं.
नहीं आया है.
Your Lordship.
आपको मालूम नहीं है यहाँ पे कितना ऑर्डर हम लोग.
Lordship, I am appearing.
Notification why, but he has not joined the office.
Miss.
Yes.
Here, if Mr. Kislev Prasad has received the wakalatnama from the APF, Your Lordship, but since he has gone to attend his uncle's funeral, so he will file the same in due course, Your Lordship. Any next step?
तब तक क्या करें? रिकवरी हो जाने दें. क्या कर रहे हैं? आपको तो ये लोग कुछ भी नहीं कर रहे हैं. कोई अटैचमेंट नोटिस भी नहीं दिए. क्या ही कर रहे हैं?
Election 1 देखिए. Election 1 is the notice.
Where is Union of India? Union of India को बुलाइए. नए लोग आ गए, आपको मालूम नहीं है. 1 महीना का इंटरिम रिलीफ हम दे देते हैं.
हाँ ठीक है, हम कब तक हो जाए उससे कोई दिक्कत नहीं. Only till that court sits, we are nothing. We have nothing beyond that. But limited period only to that.
Union of India को जरा बुलाएंगे. ठीक है?
And one perhaps
Mr. Anil Kumar,
subject
yes.
to lordship consideration. This was the order passed in another case by your
केस में
lady.
किए हैं कुछ तो किए हैं, हमको याद नहीं, कुछ 1 महीना का टाइम दिए हैं।
This one. This is the subsequent order. One, these are the two orders passed by your lady.
नहीं, उसके बाद एक और ऑर्डर, 1 महीने, इसमें किसी में 1 महीना का टाइम दिए हैं क्या? सेंट्रल गवर्नमेंट इंडस्ट्रियल ट्रिब्यूनल नंबर 2 है
जी, धन्यवाद।
मिस्टर अनिल कुमार को बोलिए, एक उनको बोलिएगा, ऑर्डर अभी 2-3 दिन पहले भी किए हैं, पंकज ने लिया है वो ऑर्डर, ठीक है, पंकज ने लिया है ऑर्डर, थोड़ा देर 10 मिनट में आइए, 10 मिनट में आइए, वो उसी तरह का ऑर्डर करेंगे। मिस्टर अनिल कुमार को जरा बुलाइए।
BA 10242 of 2024.
Release for grant of regular payments. Earlier thrice rejected.
What is the status of the?
All the witnesses have been examined in this case, my lords. Last witness examined on, my lords, 27th February 2021. 4 साल अब तक हो चुका है। 27 to 2021.
अभी तक ऑर्डर नहीं हुआ?
अभी तक कोई ऑर्डर नहीं।
ऐसा कैसे हो सकता?
अब वही तो हजूर इसका मंगा करके देख लिया जाए, और हम लगभग 7 साल
स्टेटस मंगाते हैं,
मंगा करके देख लिया जाए कि 6 साल 8 महीना से हम कस्टडी में।
नहीं, स्टेटस मंगाएंगे भैया,
हजूर
आप
मंगा
बहुत
लें।
सीरियस बात आप बोल रहे हैं।
हजूर मंगा के देख लें।
हाँ, बिकॉज अगर इतना दिन हो गया है, लिखिए, BA नंबर 10242 of 2024. Office is directed to call for the status of the case in connection with ST case number 267 of 2018 said to be pending before the learned district and sessions judge first Garwa. State नहीं है?
हजूर का भी जो लास्ट ऑर्डर है,
एक सेकेंड, the counsel for the petitioner has submitted that the last witness on behalf of the prosecution was examined way back on 27 to 2021. And since then, the case is pending. आपको कोई डिफेंस एविडेंस नहीं देना?
नहीं हमको नहीं देना है। एक बार जो
आने दीजिए, स्टेटस आने दीजिए, बिना
और
स्टेटस
हम
देखे तो बहुत सीरियस बात है इसको।
अब हम कस्टडी में हैं, जो भी नोट कर लिया जाएगा, 22/4/2018 से हम कस्टडी में हैं और कोई विटनेस सपोर्ट नहीं किया, इसके बाद भी हम जेल में।
He has submitted that in connection with the present case, he is in custody since
22 April 2018.
the status report should indicate the reason of pendency of the case and also the time which is likely to be taken for disposal of the case. Communicate करिए, रख देते हैं 7 तारीख को, 10 तारीख को, post on 10th of January. Nobody appears on behalf of the state.
For admission, item 15 WPC 3151 of 2015.
Can instruction withdraw this resolution?
WPC number 3151 of 2015, counsel for the petitioner, Mr. नाम बताइए अपना अपना Deepak Kumar, on instructions of Mr. Vishal Kumar Tiwari.
Yes,
Seeks permission to withdraw this writ petition. Permission is accorded. This writ petition is dismissed as withdrawn.
साइन कर दीजिए.
Communicate.
Item 16, WPC 4595 of 2016.
We will file
Sorry?
contract. In this matter, we will file contract. Contract will be not filed.
Petitioner absent है by way of last indulgence हो ही गया है तो क्या चीज़ का contract? Petitioner is not interested. Simple. Nobody appears on behalf of the petitioner. The case was lastly taken up on 27/2/2024, and time was paid to the petitioner by way of last chance. Neither any adjournment slip has been circulated, nor any prayer for adjournment has been made when the case is called out. Counsel for the state is present. This petition is dismissed for non-prosecution.
Item 17, WPC 857 of 2017.
Yes, petition.
Not making any compensation. The rising land of the petitioner to be used for construction of our substation. In spite of my action, they have not paid any compensation, although notices were issued to me by the financial adhikari. We submitted all the documents for the adhikari.
Where is the notice issued to?
Notice was issued to me, to my ancestors who were
When was it issued? They have not filed any contract till it. इतना दिन से अभी तक काउंटर का भी ऑर्डर नहीं हुआ इसमें. ऐसा कैसे? The matter was adjourned because we wanted to examine the provisions of Indian Telegraph Act read with Indian Electricity Act. क्या हुआ?
तो पावर
क्यों ऐसा ऑब्जेक्शन था?
तो वहाँ पर बना दिया है उन्होंने पावर स्टेशन बना दिया.
पावर स्टेशन बनाया है कि सिर्फ लाइन बनाया?
ना पावर स्टेशन पहले ब्लॉक बनाने का था, ब्लॉक ऑफिस बनाने का था, उसको हम लोग ऑब्जेक्शन किया तो वो वहाँ से हट गया. उसके बाद ये पावर स्टेशन सब पावर स्टेशन
कहाँ लिखे हैं सब पावर स्टेशन बना है?
ये
पैरा नंबर
ब्लॉक का था पैराग्राफ 25 पेज 24.
ये कहाँ लिखे पावर स्टेशन बना?
इसके बाद पावर स्टेशन बना था.
During the pendency of this case.
हाँ, during the pendency of this case. First of all, they wanted to construct building with regard to their block office. He objected not, that was shifted. Then thereafter, block substation during the pendency of this application, they have already constructed some power station without paying any compensation. रहती लैंड था 9 एकड़ 41 उसमें 2 एकड़ कट बना दिया. उनका काउंटर में फिर क्या है
किसको पार्टी बनाएंगे इसे? Who is the party? Jharkhand Bijli Viren. Why is there a private party? Respond number 10.
इलेक्ट्रिकल सुपरिटेंडेंट है, जनरल मैनेजर,
रेस्पोंडेंट नंबर 10 किस लिए बना है?
रिस्पोंडेंट मैनेजिंग डायरेक्टर, टेक्निकल पावर,
किस लिए बना है?
शायद वही कॉन्ट्रैक्टर होगा।
शायद से मत बोलिए ना, जब बन ही गया है तो अब कॉन्ट्रैक्टर का तो कोई काम नहीं।
हाँ तो ठीक है, इस पर नहीं जाएंगे। बाकी लोग जो है अगर कंपनसेशन दे दिया तो मेरा इंटरेस्ट हो जाएगा, लेकिन हमारा इंस्ट्रक्शन है कि नॉट ए सिंगल पार्टी हैज बीन पेड। यही जमीन था जहाँ
Counsel for the petitioner is present. Nobody appears on behalf of the respondents. The counsel for the petitioner has submitted that the private property of the petitioner has been utilized for construction of powerhouse, power substation, but no compensation has been paid to the petitioner. He has submitted that the property was earmarked by the Annexure 11.
Yes. Annexure 9 है जो नोटिस आया है 1934 का है, 64,
And has submitted that notices were also issued by the Annexure 9 series. Correct?
हाँ, अंचल अधिकारी का नोटिस।
Let notice be issued up, एक second. Let notice be Central Government Industrial Tribunal number 2 functional है कि नहीं? थोड़ा सा वेरीफाई
लास्ट टाइम जो हमको बताया कि उसके बारे में जो इन्फॉर्मेशन है शायद उसी के लिए।
हाँ अभी वाला 1 तो हो गया है, ये 2 फंक्शनल है नंबर 2।
हम पता कर
थोड़ा सा बताइए, ऑर्डर करना है आज। Let the counsel, the respondent number 2 to 9 are directed to file counter affidavit in this case. इसका रेस्पोंडेंट का नाम एक्टिव कर रहा है, आप ऐसा कर दीजिए, इसको नोटिस कर दीजिए, तो आएगा नहीं, हम इनको बता रहे हैं। लेट नोटिस बी इशूड टू रेस्पोंडेंट नंबर 2 एंड रेस्पोंडेंट नंबर 5 through speed post. The requisites be filed by Wednesday. नोटिस करने के लिए 2 वीक्स आपको चाहिए। अभी हम लोग कहाँ छुट्टी पर? By Wednesday.
By Friday.
By Friday. Pose this case on 24th January, awaiting service. Office to track speed post delivery and prepare appropriate office note with regard to service of notice.
Serial number 16
आप नहीं थे, अब DFT कर दिए।
Also case item 13.
maybe
Item 13.
Who's for the petitioner? हाँ, वो तो नहीं, वो गया है, मुझे पता करने के लिए।
Item 18 WPC 890 of 2017.
Petitioner
Your Ladyship, the matter has become infructuous.
Yes.
Because the petitioner was assailing and
Panchayat election, public counting.
WPC number 890 of 2017. The learned counsel for the petitioner on instructions from Mr. B.C. Mishra,
yes,
advocate on record, submits that the case has become infructuous and he does not want to press this petition anymore. Counsel for the respondents state
Yes.
has no objection to the prayer. Nobody appears on behalf of private respondent. Considering the submissions, this petition is dismissed as not pressed.
Sign.
अपना नाम दीजिए and sign करें. What's your name?
Aditya Banerjee.
Aditya Banerjee.
Item 19, WPC 2402 of 2018.
Yes, teachers. Also, in this case, the petitioner has prayed for a direction upon the respondent as to so cause as to under what authority of law they have constructed a public land on the private property of this petitioner. They have filed a counter affidavit in which counter affidavit they have said that the petitioner had not brought on record the documents pertaining to right title and interest of this petitioner, this property. I have filed it by way of supplementary affidavit and brought on record the khatiyan as well as the current receipt as well as the land village map etc. to demonstrate that the land
Was there a road earlier?
No, Your Lordship. In fact, Your
Where
Lordship,
have you stated that there was no road?
I have stated, Your Lordship. Paragraph number 11, Your Lordship. This is said to be pointed out that adjoining to the plot of the petitioner there was another village road which is easily accessible by the local residents, and the road in question was not acquired but with an ulterior motive or to satisfy some ego, municipal corporation has proceeded. Earlier also I have given a specific statement also that we have simply allowed few of our village family members to go or to pass from that road, and treating the same to be a public road they have proceeded.
So there was some road over there.
Not on my plot but adjacent to my plot, and instead of making a construction because the nearby persons who was there has obstructed them not to construct.
What is the date on which the construction was made? Where is your representation? Did you file any representation?
Yes, right. You'll may have a kind of two paragraph, page number 17, initially 2009 letter you'll see. टाइप कॉपी इस उपरोक्त विषय के संदर्भ में ध्यान आकृष्ट करते हुए सूचित करना है कि करमटोली है टोली सच एंड सच संज्ञा के अधीन हमारा नाम से इतना एकड़ भूमि है जिसमें इतना एकड़ भूमि पर रांची नगर निगम द्वारा पक्की सड़क बनाई जा रही है। हमारे अनुमति के बिना हमारा निजी भूमि में सड़क बनाने रोकने हेतु आवश्यक कार्रवाई की जाए, अन्यथा बाद में होकर माननीय उच्च न्यायालय के सर 2009 हुआ। thereafter I have approached to the there are other representation just thereafter also, that is dated of 2016. Thereafter I have even travelled to the Janta Darbar before the Chief Minister's office, Your Lordship, and they have also asked by annexure 4 page 19 to the concerned.
Who's for the respondent?
I for the state. Ranchi Municipal Corporation is big party.
Where is Ranchi RMC?
His name is written.
So what should I do with that name?
We are from the state.
The road has been constructed by the municipality.
Yes.
They have not filed any affidavit. Have you served copy on them?
Yes, Your Lordship. They are appearing. Their name is also there.
Whose name is appearing?
Respondent number 456.
नाम बताइए.
Mr. Sahib.
They have not filed any counter affidavit so far. Have they?
Counter state here. One counter has been filed, Your Lordship, but that is by. Your Lordship, sorry to say, Your Lordship, they have filed it. In fact, the counter affidavit on record is theirs.
Where is it? Where is the counter affidavit?
Counter affidavit is dated 6th March 2019. Your Lordship.
You filed a complaint before Honorable Lokalyukt also.
Yes, Your Lordship, but alleging corruption, but they said that this is not a matter of corruption and that has been disposed of. Even before the Honorable Chief Minister's.
You were asked to make such. There were letter was issued to you to produce the documents, right?
Yes, I have
but you did not.
I have produced, Your Lordship. I have even brought on record before this Honorable.
No, by virtue of letter dated in response to letter dated 18/8/2017, did you produce the documents before then?
You see, I have. I'm not specific about that, but I must say that I have.
No, there is a letter. You go and respond to that letter.
No,
You satisfy them.
we have represented there with all documents, Your Lordship.
Where is it? You see, there is a specific letter number 18/8/2017. Did you respond to this letter?
We have responded, Your Lordship, but I.
Where is it? Where is the response? You have filed a rejoinder also. Where is the response of that letter? बताइए.
But now, Your Lordship, though I am not having that particular communication, but I have filed the supplementary affidavit and that is all before Your Lordship's kind consideration. So, Your Lordship,
We'll ask them to consider.
Yes, Your Lordship.
Whatever it is, you go and file a representation and they will consider. That is it. You can't do anything more because they asked you to supply certain documents which you did not.
We have supplied it, Your Lordship. We have given this.
Okay, you supply it fresh. WPC number 2402 of 2018. Counsel for the petitioner and the state is present. Nobody appears on behalf of Ranchi Municipal Corporation. Counsel for the district petition has been filed for the following relief. A counter affidavit has been filed on behalf of Ranchi Municipal Corporation. The grievance of the petitioner is that on his private road, on his private land, road has been constructed by Ranchi Municipal Corporation, correct?
Yes.
And there has been no acquisition of land. Counter affidavit has been filed on behalf of Ranchi Municipal Corporation stating in paragraph 4 that after receipt of complaint of the petitioner, Ranchi Municipal Corporation by RNC letter number 1866 dated 18/8/2017 asks the petitioner to submit land ownership papers of the plot in question, but the petitioner failed to submit any document with regard to ownership. And he was again asked for ownership papers by letter number 301 dated 2/2/2017. The learned counsel for the petitioner submits that all the required documents have been placed on record before this court through supplementary affidavit.
In rejoinder, paragraph number 8 we have seen.
He has also referred to paragraph number 8 of the rejoinder, stating that the documents were submitted by Annexure 9 dated 3/4/2018. It appears that from the perusal of the records, it appears that there is some confusion with regard to submission of documents by the petitioner. However, the counter affidavit of Ranchi Municipal Corporation reveals that they were ready to consider the documents which could have been submitted by the petitioner. And for that purpose, letters were also issued by Ranchi Municipal Corporation. In such circumstances, this court disposes of this writ petition, enabling the petitioner to file a fresh representation before the respond number 5 or 4.
5 will do an executed sitting officer fashion.
यही चलेगा ना? Before the respond number 5, along with a copy of the writ records and the required documents for consideration within a period of 15 days from today upon filing of such a representation. The respondent number 5 shall grant an opportunity of hearing to the petitioner and pass a reasoned order in accordance with law within a period of 4 weeks thereafter. The reasoned order be communicated to the petitioner through speed post and also through email at the details to be provided by the petitioner in the representation. It is made clear that this court has not gone into the merits of the case of the petitioner. It is for the respondent number 5 to pass appropriate orders in accordance.
If they are passing any favorable order, then monetary benefit.
तो क्या ही फेवरेबल ऑर्डर, अभी तो कुछ बोल नहीं सकते हैं.
उसके बाद फिर अगर कर देंगे तो फिर
देखते हैं क्या बोलते हैं, किसका टाइटल है, क्या है, पता चला मिस्टर क्या कौन है? फ्रॉम भुवनेश्वर है ना, जो एक केस में ऑर्डर किए उसी तरह का ऑर्डर कर देंगे ना. भुवनेश्वर कहाँ गए?
Both the tribunals, my lord, 1 and 2, he has been obtained.
Okay. I will just record your submission. वो एक ऑर्डर किए थे लाए हैं? नहीं, ये तो वो दिए थे, हम लोगों ने लिखे WPL number 6291 of 2024. What Mr. Alok Lal, learned counsel appearing on behalf of the petitioner. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner has filed appeal against the order dated he has submitted that an order dated 12/8/22 was passed against the petitioner under section 7 capital A by the respondent number 1, and the petitioner was directed to pay an amount of rupees 19,21,878 as EPF and allied dues pertaining to the period 1/2001 to 6/2019. Against such adjudication, the petitioner has preferred appeal before the appellate authority, which has been registered as IT-2-79 IT-2/79/2022 along with application for stay. And the appeal was fixed for final hearing. He submits that during the pendency of the appeal, the respondents have taken steps for recovery by letter dated 18/10/2024. And summons under section 83 of second schedule to the Income Tax Act 1961 was issued. The learned counsel submits that the appellate, the post of presiding officer of the appellate authority is vacant, and therefore the petitioner has been rendered remittless. Therefore, this writ petition has been filed, seeking appropriate relief during the pendency of the appeal. Mr. Anil Kumar, Senior Advocate and ASGI, was called upon to inform this court as to whether the Office of Central Government in District Tribunal cum Labour Court number 2 is vacant. We have submitted that although there is no regular presiding officer, but alternative arrangements have been made by giving additional charge to the CGI, to the presiding officer of CGIT Bhubaneswar. Considering the aforesaid submissions, this court finds that although no regular presiding officer has been appointed in Central Government in District Tribunal number 2 at Dhanbad, but alternative arrangements has been made. In such circumstances, the operation of the Annexure 1 to the writ petition is stayed for a period of 1 month so that the petitioner may seek appropriate relief from the appellate authority as and when the presiding officer, Central Government in District Tribunal from Bhubaneswar, holds the court at Dhanbad. It is made clear that if any recovery has been made pursuant to Annexure 1, then under such circumstances there is no question of refund of the amount to the petitioner, and such recovery would be subject to the final result of the. That's all. You are for HCT.
I'm mentioning serial number 32 as a personal appearance, and tagged, not tagged exactly, but the related review has been posted for 17th of January. 32. Petitioner, my lord, they are here. Petitioner, the other party, they are here, the intervener. They are also here.
अभी 1:30 बजे मेंशन कर रहे हैं, 2:15 बजे आएगा. This writ petition is accordingly disposed of. एक ऑर्डर है हमारा, उसी अनुसार इसको मॉडिफाई कर देंगे थोड़ा सा. इतना ही रिलीफ देते हैं और वहाँ पर आप अपना प्रेयर.
कोर्ट बैठ ही नहीं रहा.
नहीं बैठेंगे ना. 1 महीना का आपको रिलीफ दिए हैं. अगर उसमें 2 महीना का होगा तो हम आपको सिमिलर रिलीफ दे देंगे। आपको याद नहीं है कि वो ऑर्डर मेरे पास आया नहीं है, हम एक केस में किए थे ऑर्डर।
मिस्टर निकुल बख्शी
हाँ
मिस्टर निकुल बख्शी वाला
नहीं, कई सर मिस्टर निपुण बख्शी वाला तो ऑर्डर है, लेकिन वो CGIT धनबाद वाला
CGIT धनबाद वाला ही है।
आसनसोल है ना इसमें। उस समय आसनसोल थे, नहीं एक भुवनेश्वर वाला भी किए हैं। हम देख लेंगे उसमें इंटरिम रिलीफ थोड़ा अगर ज़्यादा होगा तो आपको ज़्यादा देंगे। आप लोग सुबह मेंशन नहीं करते हैं, आप इनको बिठा के रखते हैं
पास बनाने और इसमें टाइम
नहीं सुबह 10:30 बजे से यहाँ बैठते हैं। ये मत हमको, मेरी नज़र बहुत तेज है। It was here at 10
but
o'clock.
not on the first time, मतलब after many days I'm seeing that the cases are going seriator. Otherwise ये 11th case था contempt. सीरियस अगर सिर्फ contempt होता तो
आज शायद नोटिस नहीं है कंटेंट।
नहीं है इसीलिए तो आप सोचे कि ऐसे ही हो जाएगा।
कौन है इसमें पार्टी कौन?
Parties are here, petitioner is here, the intervener is here.
इसको 17 तारीख के बाद रख दें क्या? बताइए।
17 तारीख को ही रख दीजिए, सेम डे
17 को रख दें।
17 को ही रख दीजिए।
आप उसमें वकालतनामा फाइल कर दिए हैं रिव्यू में, उस दिन रख देते हैं।
इसमें they have to file the reply letter.
I will file it.
कोई बात नहीं, 17 को रख देते हैं। ठीक है, इनका पर्सनल अपीयरेंस रिकॉर्ड करिए। काउंसिल फॉर द पार्टीज आर प्रेजेंट at the request of the respondent. The matter is opposite party होगा ना ये? At the request of the opposite party, the matter is adjourned and is directed to be posted on 17th of January. In the meantime, the earlier order passed by this court be complied by